Ready? 1, 2, 3, start. Since the second and third respondents have not been served, let the second and third respondents be served. Such respondents will be informed that the matter will appear on April 29, 2019, and the appeal may be proceeded with in such respondents' absence if they are not represented. Parachange. The case of the appellants is that the appellants entered into a previous agreement for purchase of the relevant property from the respondent numbers 2 and 3 herein. Subsequently, the appellants agreed to relinquish their right under the relevant agreement upon receiving back the advance of rupees 30,000 and being paid a further sum of rupees 3.80 crore. The appellants were confirming parties to the subsequent agreement for sale entered into between the respondent numbers 2 and 3 as vendors, and the first respondent plaintiff as the purchaser. Parachange. There is an anomaly in the relevant clause in the subsequent agreement for sale in that it appears that the appellants herein had already received the payment due to them for relinquishing their rights in respect of the property in question. However, it appears from subsequent admitted documents that the appellants have not been paid the entirety of the sum of rupees 3.80 crore that they were to receive as compensation in lieu of their relinquishing their rights in respect of the property. Parachange. The order is based on a letter dated July 6, 2018. It is the contention of the appellants that the order goes against the cardinal principle of an admission being incapable of being divorced from the conditions attached to the same. According to the appellants, the relevant letter clearly spelled out that the appellants were obliged to and would execute the deed of conveyance subject to receiving the balance consideration. According to the letter and the admitted position qua the plaintiff, a sum of rupees 2.30 crore may still remain due and owing on account of the amount of rupees 3.80 crore referred to in the agreement of cancellation or relinquishment. Parachange. Though the plaintiff has been required to deposit the entire balance consideration that the second and third respondent vendors would be entitled to receive, the claim of the appellants has not been dealt with in the judgment and order impugned. The appellants say that it is inconceivable that the appellants would execute the deed and thereby irreversibly abandon their rights without receiving the consideration for having agreed to relinquish the rights. The appellants insist that the balance payment due to the appellants must be simultaneous with the appellants executing the deed of conveyance. There is substance in the appellant's assertion. The order impugned will remain stayed till the disposal of the appeal. Certified website copies of this order be made available to the parties upon compliance with the requisite formalities. The delay in approaching the court has been sought to be explained in the following words: that the petitioner submits that the petitioner is a inhabitant of a remote village, and from the long time ago he was suffering from various disease due to old age, and moreover he had no knowledge about the legal procedure to approach before the proper judicial forum for get relief. Time without number he visited personally with the concerned treasury officer as well as the concerned district inspector of schools, Howrah, and requested them to sanction and release 18% interest upon the gratuity amount for delayed payment very recently, and he personally met with the concerned treasury officer to release the 18% interest on the gratuity amount for delayed payment, but the concerned treasury officer straightway rejected the said prayer of the petitioner